The primary focus of today's chat is really to talk about commercial deals and the impact of Corona, and whether you might be able to invalidate your contract, or whether the service provider, if you're not the service provider, is able to invalidate their contract based on a force majeure event. In this case, that would be obviously COVID-19. So I'm just going to kind of go through an overview of what you might want to do in terms of evaluating whether your contract applies, whether you will be able to invalidate, or whoever is seeking to invalidate has legal standing to do so based on the coronavirus. And obviously, kind of the first thing that you want to do, which goes without saying, is you want to make sure that your contract has a force majeure clause. Most boilerplate contracts are going to have it in some form. Up until now, probably wasn't looked at very carefully or very closely. And some contracts, for instance, I'm thinking of, one-page construction contracts that a lot of people enter into with their contractor when they're looking to renovate their home. They'll get a one-pager from a contractor. Those might not have it. Corona might still impact that because a court might find that the contract's impossible to perform upon, or impracticable, or the purpose of the contract's been frustrated, and we'll talk a little bit about that later. But if you have a contract, you should review the contract and figure out what obligations you have in order to invoke force majeure. So very often there's a notice requirement. You have to give prompt notice to the other side that you're seeking to invoke it, and how the event, in this case Corona, and it's pretty obvious how it's going to happen, but how it's going to impact the performance of the contract. The most important piece is the actual wording of the clause, because the courts have taken the view with respect to these kinds of clauses that it has to be explicitly stated in the clause what the event is going to be. So most contracts are probably not going to have pandemic, epidemic, public health emergency. If you're in a business right now and you're writing a contract, or you're reviewing a contract, you're going to obviously want to make sure that something like that is in the contract, because it's very likely we're going to be dealing with this or some form of this for the foreseeable future. And I'm sure every contract is going to have pandemic or epidemic, or even just coronavirus specifically spelled out in the contract. But you should take a look at your contract and see if it has any language like that to begin with. If it doesn't, that doesn't mean that you're out of luck and you're going to be forced to perform, or on the converse, if you want to perform, that you're definitely going to be able to perform, because there might be other language such as acts of God or events beyond the control of a party. And I think we could have a really good, rigorous debate about whether or not Corona is covered by those things. We've had an internal debate about that over the last couple of days, whether the coronavirus itself is the event that's going to prevent a party from performing, whether it's the spread. If it's the spread due to people going outside and still shaking hands and going on the subway, is that an act of God, or is that human beings kind of contributing to the spread? And this is not something that has a black and white answer. This is something that's going to be litigated. The courts are going to make a decision. And from a practical perspective, you can probably take either side. If you're looking to invalidate a contract, and there's an acts of God or events beyond the control of a party provision in your contract, you can definitely take the position that Corona falls in that category, and you or your attorney can use that in giving notice to the other side that you're not going to be performing on the contract. On the other side, if you do not believe that there's a clause that covers non-performance and you want to make sure that you're going to move forward with the contract, you can make some of those arguments that I spoke about. This isn't an act of God. This is a man-made crisis. And this is something, no doubt, that the courts will litigate probably in the very near future, because there will be all kinds of emergency applications made to the courts once they open back up. Probably in a crazed fashion, we'll see a ton of litigation surrounding this. And over the next few years, my feeling is that, this is just my personal feeling, this isn't legal opinion, that most courts, particularly courts where this is having a widespread impact, like in New York, are going to take a pretty expansive look at acts of God, events beyond the control of a party, and find that Corona has made it impossible or impractical to perform on many kinds of contracts. That's just a guess. There's really no precedent for something like this really in the last 100 years. I think we mentioned the Spanish flu in our email. That's the closest comparison, but that's over 100 years ago. Things have changed, and how that epidemic was dealt with is obviously very different than how this one is being dealt with. So you're going to want to take a look and see whether or not the event, i.e. the coronavirus, is covered by your contract. And the next piece is you want to be sure that the coronavirus is the reason that you're unable to perform under the contract. And that seems kind of obvious or apparent, but there needs to be a causation. There needs to be a link between the virus itself, in this case, that's the event that is preventing performance, and the failure to perform. If the other side can make a really good argument that there's no link between the virus, which I can't think of off the top of my head right now. I don't know if Mike or Cooper, you could think of a situation where the virus wouldn't be the cause of the failure to perform. But you're going to have to be able to establish that. And again, you know, a lot of this is going to come down to the parties or true lawyers talking through this, and both sides kind of manipulating the language of the contract to meet their end, just like any other dispute. But here, you know, you also have the emotional chord to tap into. This is going on right now. It's very real. It's very obvious. And if you're seeking to get out in front of something and you want to make sure that a contract's invalidated, I'd say striking while the iron is hot, while this is really fresh in people's mind, and they might be more willing to be accommodating. They might be more willing to accept you stating that you're no longer going to perform. I think that, you know, doing it quickly rather than waiting and seeing what happens is probably a good thing. If for whatever reason, you know, it makes sense for you to wait and see whether things improve, whether the outlook isn't quite as dire as many in the news are making it out to be. Certainly you could take a wait and see approach. The clause doesn't go away. However, there might be a notice requirement in the clause, in the contract. And if you're not abiding by the notice requirement, you might lose the ability to invoke your force majeure clause. So that's just something to keep, you know, keep tabs on. And even if there's not a notice requirement, courts typically want you to, you know, move forward as quickly as possible. People make business decisions based on the number of contracts they have, based on the amount of money they think they have coming in. So if you wait 2 months to invoke the clause, and the clause is something vague like acts of God, not vague, but undecided, you might have less of a chance of having your non-performance stand up in court later on, because the court might say, why didn't you do this, you know, right away? You knew what was going on. You're going to want to see if there are exceptions or exclusions. No, I find it very unlikely that anybody foresaw this happening if they entered into a contract before Corona. But perhaps, you know, if you entered into a contract last week or a couple weeks ago, and whoever was drafting inserted certain exclusions or exceptions, that might be different than a contract that was entered into a couple of months ago before we even knew about this. Then there's just kind of practical considerations. So my daughter's walking into the room. Parker, say hi to the room.
Hi, Parker.
That was an unintended event. So
I would argue that was foreseeable, Lee.
That's affecting performance of this video.
Actually,
Okay.
Lee, before you, that was a good interruption without me being rude, because I was devilishly sitting here thinking of examples of where there would not be causation.
Yeah.
And this is a really devilish one. So you have a small staff, you depend on them to deliver on your end of the contract. They all come down with the regular flu last week and nobody can perform, and you're about to close up shop. Coronavirus comes along. There's a shelter in place, or it's suggested that everybody work from home. That would be like an issue of fact, where if you were the counterparty and you were trying to show that there wasn't a cause, I mean, that would have to come out in depositions, I guess, but that would be an interesting one where it's able that your whole small staff can catch the regular flu, and it's treated so differently.
Yeah, I mean, I'm using Corona as pretext if there was a failure to perform before Corona really impacted the contract. So that certainly could happen, and that probably is going to be more liable to have happened like the last couple of weeks or
Right.
in May or June, where someone comes forward and says, I can't perform on this contract in June, where the services are meant to be performed or the goods to be delivered in June. And it might be too early. It might be premature to say that, or, they might just not have wanted to perform. So they're using this as the reason.
No. Here's another good one. Night before, as this news is all breaking, we find out that Saudi Arabia and Russia can't agree on an oil supply level, and oil prices tank. Now if you're in the oil business, that's a big problem. Was that exacerbated by coronavirus fear? Probably. But
Yeah.
how much? How do you prove how much of that drop was caused by it?
I don't think we
Not
have
all
any.
solutions.
I don't think we have. I don't think we have any clients in the oil business. But if we do, that could be a very.
We would take them on.
So I think before my daughter foreseeably interrupted this chat, we were talking about some practical considerations. So look, I think everybody who has this clause in their contract in some form, or even if you don't, because of the doctrines of impossibility or impracticability or frustration of purpose, there's going to be a good faith argument to say, I'm not going to perform. One of the things that you're really going to have to consider, and anybody who's watching this or here knows this, but you need to weigh the risks. And typically those are going to just be business risks, your reputation in the industry, your relationship with a critical customer who's relying on your performance here in order to maintain the long-term relationship with the customer. Whether there are terms in the contract that by invoking this clause, you give the other side the ability to terminate. So we don't really know how long this crisis is going to go on for. By most indications, it's going to be at least a few weeks, probably closer to a couple of months, on and off potentially for the next year or more. But if it's on the lower end of that threshold of some of the steps that New York and the rest of the country are taking in place, I hate everybody's using the phrase flatten the curve, but if that happens, and the contract is one that's long-term, and you invoke the clause now to get out of doing something for the next month or month and a half, and that clause allows the other side to terminate, it might, from a business perspective, you might have to weigh paying a little bit more now for a non-product versus terminating the relationship. I'm going to give a really, basic example, which is daycare, right? A lot of, and this is something that I'm thinking about now. Daycare is continuing by way of daycare and school are continuing by way of Zoom hangouts, by video hangouts. You're still paying full freight for a very small portion of the daycare. Daycare in New York City is very hard to get into the kinds of schools that you want to get into. Is it worth the risk to, invalidate the contract or stop performing under the contract by stopping paying and losing your ability to remain with that institution long term? That might not be perfect because that's not a force majeure clause. Most of them are month to month, but just an example of thinking through before you invoke how it's going to affect your business, how it's going to affect your business relationship, whether you are sacrificing long-term goals for short-term money, because during a crisis, people react quickly. They want money on hand. So you need to think through some of your longer-term goals before invoking the clause or before trying to invalidate the contract. We talked about notice a little bit. Really, really important, though, if you have a force majeure clause, to make sure that you're complying with the notice provisions. Talked about termination. There might be a duty to mitigate. So you might have to take certain actions to reduce the period of delay that the event causes. So Corona might, again, things might get better. You might be able to start doing certain things that the virus had previously prevented you from doing. And you just have to make sure that you're mitigating in that regard. So the final thing that I wanted to say before we jump into some questions and some additional thoughts, and I know Mike wanted to talk a little bit about commercial leasing too, because I think we have some clients or some some contacts on here who have commercial leases or who are in the real estate space, and they're thinking about how this impacts their leasing, both on the landlord side and on the tenant side. So Mike's going to talk about that for a few minutes after I finish here. But look, many of us are still running businesses, and we shouldn't stop running your business. And that means entering into agreements. You're going to have to really give major thought to this for any contract you enter into. Not even if you're in business, but just if you're getting services from somebody, if you're entering into a real estate contract, if you're hiring somebody to do improvements on your home, if you're hiring a nanny, anything from the most mundane to higher level corporate stuff. This is going to be a clause that you're really going to have to take a close look at. Make sure that you're drafting really well. Make sure that you're really specific with respect to this virus moving forward, that you have something that references public health emergency, epidemic, pandemic, local disease outbreak, quarantine, so that you're protecting yourself and your business moving forward. Now there's no excuse for not including it. Before there was, and you're going to be able to make the argument that it might be covered by acts of God or otherwise. But if you entered into a contract yesterday and you're seeking to invalidate next week and you don't have pandemic or epidemic, I think you're going to be on a much worse footing to try to enforce, both from like a practical perspective. So when you reach out to the other side and say, oh, look, I know we entered into this when it was kind of bad. Now it's really bad. They're going to say, well, you knew about it. Why didn't you explicitly reference it in your contract? And that's going to be the case moving forward too. We can't just think in terms of this is going to be over in 2 months, so we don't need to be really specific about epidemics or pandemics. The likelihood is this is going on for a while, and if you're drafting contracts over the next couple of weeks, next couple of months, you have to make sure that you include it. And I'll let Mike talk about some commercial leasing considerations, and then we'll see if anybody has questions or thoughts or just wants to talk about frozen, which is a big topic of conversation in my household right now, or otherwise. So Mike, why don't you just take it over?
Yeah, no problem. So it's sort of a unique issue in the residential leases. Obviously, those are more important than ever, right? You need a place to shelter in and socially distance yourself. So we're really just focused on commercial spaces where, you've entered into an agreement with a landlord, and the landlord is agreeing to provide you access to the space. Depending on how it's drafted, maybe they're providing utilities, but they're providing building services also in addition to access to the space. You really, as the counterparty in the lease, are obligated to pay rent. That's more or less your only obligation. If it's a triple net lease where you're going to be paying for other things that normally would be the landowners or the building owners, it can be different. But in your just plain vanilla gross lease, we would call it, your obligation is to pay the rent. So it becomes a little bit difficult. Most commercial leases, I don't know that I've ever actually seen one that wasn't drafted this way. The force majeure clause will provide for the circumstances where the landlord failing to provide access and services is excused from performance so that you don't owe them rent. So what do I mean by that? If there's an act of God, or if, let's say, it says a pandemic forces them to shut down the building, well, that doesn't excuse your performance as a tenant. You still have to pay rent. That's outside of the landlord's control. Okay, so landlords are always trying to limit circumstances in a force majeure clause wherein the tenant doesn't have to pay, to circumstances where it's an act or omission on the part of the landlord that causes the delay in services or the interruption of your access to the space. So that makes it a little bit difficult if you're a tenant, because usually there's nothing in there that speaks to your obligation. If you have a bad year, if something affects your business and you can't pay, well, most landlords are going to take the base position that that's the risk you take when you enter into a lease. You're engaged in business, and just like being able to feed your family and generate income from your business, you're taking a risk that you may or may not be able to do that depending on what comes down the road in life. The obligation to pay them rent is no different. This is the landlord side. This is a little bit different though, because here, I'm thinking specifically about, really all businesses, especially in New York City, are affected. But let's take restaurants, for example, or someplace where you are you're providing a service, a studio of some sort, a movie theater, things that you specifically cannot operate right now, and you're clearly going to have a big dent in your business because the government is actually saying you cannot operate a restaurant for sit-down service right now. If you didn't have takeout capabilities, you're completely out of business right now. So one of the things we've been looking at, just firm-wide, is what are some other things we can hang our hat on? Frustration of purpose, meaning we entered into this contract with the intent of being able to operate a business out of it. Due to no fault of our own as a tenant, we're now being told we absolutely cannot operate here. It's because of this pandemic. That's going to be a hard one. It's going to be a hard one for the court to ignore. It's kind of an equitable issue. It's not something that we would expect to find written in any lease. And even if you tried to negotiate for something like that going forward, if you hired a lawyer as a tenant to negotiate for some kind of tenant-friendly force majeure provision, I think there's still going to be a lot of pushback because there's a lot of room to take advantage of that to say we don't have to pay. The impossibility doctrine. I mean, in a lot of cases, we were kind of going back to law school days with these common law contract principles that you don't think about very often because you have a lease that spells out, if you have a 150-page lease in some cases, that spells out a lot of the situations that are going to come up. Every once in a while, the future doesn't always track the past, right? I don't even think this is comparable to the Spanish flu because I don't think we didn't have social media or, instant news updates that would cause people to mobilize. I think part of the problem with that epidemic was people didn't know enough to stay home or to avoid spreading it. So this is kind of a unique situation. I mean, even just talking to parents and grandparents, nobody can really remember a time where everything was kind of shutting down. And if you think about it, you couldn't operate this way, even if you were just a regular, executive or administrative office, if we didn't have internet access. Like this couldn't be taking place. We'd be forced to write letters to each other. And that's how we would conduct business or make phone calls. So it's a novel issue, I think. And whether it's force majeure or frustration of purpose, that's, we would rather not get that far where we have to actually litigate on that. I think that practically speaking, landlords, especially in New York City, are going to have to come to the table and, really make a hard decision. Do I negotiate for deferment of rent or do we excuse a couple of months of rent? They're going to have to do something to keep these otherwise very good tenants in place so that they're not left with a vacant building. I mean, they can sue all their tenants and, evict all of their tenants, but who are they going to replace them with? So if you're on the landlord side of this, it's not that easy an equation to figure out either. Because you don't want to set a bad precedent and you also don't want to be left with a vacant building because it's affecting everybody. Even if you're diversified, across, let's say you own property in New York City, New Jersey, Omaha, LA, all of a sudden being geographically diversified doesn't really help you either because it's happening everywhere. I think Cooper was.
You guys hear me?
Yeah.
I'm wondering if you have any thoughts on whether negotiating. Let's say I'm leasing a space and I negotiate with my landlord to decrease my rent, or I negotiate with my service provider, and then it's still impractical. Like I can't pay the bills a couple months later, things get worse. Do you think that negotiation could affect my ability to recover under one of these doctrines later on?
I would say so. I would say that, like anything else, it's almost like an accord and satisfaction type of thing where you're modifying the agreement. Everybody's agreeing that this is enough to get us by. And so, yeah, on the one hand, if you don't do anything now and you say, look, I'm just going to see if I can get away with this and force the landlord to sue me and then hope that the courts have mercy. I could see them probably having mercy because it's not going to be readily apparent that you didn't try and the landlord didn't just shut you down, it'd be an issue of fact, I guess. But if you actually come up with an arrangement, and especially if it's put on paper, just like in a commercial lease, I think a judge is gonna be a little harder to persuade that they should give mercy to you.
Yeah.
You now know all the facts, right? Before coronavirus, you didn't know that such a thing could disrupt business across the board. So it's almost like it's a little easier for a judge to say, well, nobody can predict this. Even sophisticated parties who hire counsel and both parties spend a lot of time negotiating this. They couldn't foresee this. If you come back to the table knowing maybe not all the facts, because we have new facts every day, but if you sat down today and negotiated something, at least know enough and we have potentially months ahead of us, we should make sure that we're coming up with an agreement that can work, even if things get worse and worse. It's hard to say exactly how they'd come out, but I would think that if you've had the chance to digest the information that we have today and come up with an agreement, if I were the judge, I would probably say, well, you should have maybe done more to protect yourself at that phase. And at least you got some mitigation.
Although I think the key is that you're going to want an agreement that specifically talks about what happens in the event it continues to become impossible or impractical. So if you're going to negotiate something with the other side in a commercial deal, or a landlord or a tenant, if you're a landlord, you want to just make sure that you have something on paper that reserves your rights to, invoke these principles later on in the event that this goes on for longer, circumstances change, things get worse, not better. Who really knows what's going to happen? So I think, like anything else, you just want to kind of think through all the contingencies and make sure that whatever agreement you come to with the other side, one, is on paper, so it's enforceable in some regard, and two, you think through some of these things and have contingencies in place to deal with them.
I think Mike's point, though, is an interesting one, and one to really consider, because I do think there's a lot of people who are going to be jumping into some real short-term solutions right now, immediately renegotiating things, and I think that it's important to realize that may affect your ability to recover down the line, or you're standing in a lawsuit, or because now we do have we have a new set of facts, and kind of understanding the universe of Corona, the new contract, even if it is a very short-term contract, may really, it's probably pretty important to think through what that looks like, rather than just like agreeing over a series of emails to negotiate new terms without sort of really thinking things through from a long-term perspective.
I totally agree with that, for sure.
That brings up one more thought to mind, which we've already encountered, in some cases. If you have to guarantee your lease, so your entity enters into the lease as a tenant, but the landlord requires that you give a guarantee. If it's a straight unlimited guarantee, there's nothing you can do about it. Now you and the entity are on the hook for the rent, and it's a concern for both of you. But you have a tough choice if you have what we call a good guy guarantee. Good guy guarantee essentially says, if you give back the keys, it's clear you're going to default. You notify the tenant that you will be defaulting. You're giving them back the space in the condition required, as though it's the end of the lease. Once you've done that, you can now walk away, and you personally are no longer liable after you've given back the space. The tenant entity remains liable. They can be sued for the balance of the rent, but you're out personally. Most New York City good guy guarantees have a certain notice period. 30, 60, 90 days from when you give notice, that's when your personal liability cuts off, assuming you gave the space back. So if you are giving the space back and you give that notice, you're calling it quits on that space. I mean, could you come back and negotiate to stay? I guess you could. There's no rule that says you couldn't renegotiate if the landlord's willing, but you're really, that's a tough move to make, because you really have to know that you are finished in that space and that you're not going to have regrets if things start to clear up the following week or the following month. The wheels have already been set in motion. But if you delay, you're adding, each day that you delay, you're adding another day that you're personally liable for the rest of that rent. And if you walk away from it, the first thing the landlord will do is draw down on the security deposit, and then they'll look to whatever the tenant entity has left or whatever is remaining on that notice period for you personally to look for rent. So it's not an easy decision to make, and it's something we would look at case by case with each client that came to us with it. But it is comforting, at least, to know that you have a good guy guarantee and escape clause. And I don't know if you want to get into the sublease assignment dilemma, or if you want to move on.
No, I think we'll save that for a more specialized.
I mean, yeah, the nutshell version is normally assigning or subletting is your way to mitigate your damage. You get somebody else in the space. The problem in this environment, and possibly going forward in the medium term, like the rest of the year, who's going to come in and sublet the space from you? It could be a real issue. We can delve into that maybe on next week's. We'll see what unfolds in the world between now and then.
I just wanted, before we open it up, I don't know if there's enough questions or comments, or if Cooper wants to jump in with some other thoughts. But we both mentioned in passing the doctrine of impossibility and impracticability, which I think I mentioned it when I talked about it during the initial comments, but the courts have in the past, if there's an intervening event, in this case, obviously Corona, that makes performance under the contract either impossible or impracticable, which is probably going to mirror some of the language in a really well-drafted force majeure clause, it still might invalidate performance. So if there's, again, carefully review your contract. If the clause isn't there, or if you didn't even sign a contract, if you have an oral agreement, it's not as if all hope is lost and you can't, and you're going to have to pay for the indefinite future. You should consult your attorney. You should see if there's a legal argument to be made, and even if there's not a great legal argument, is there something that can be used to give you some leverage with the other side to see if there's a way out? And between using some of these principles as leverage points, and just the environment where people are trying to mitigate to the best of their ability, trying to maintain relationships, and just trying to be kind, which I think many companies are trying to do, at least in the near term. That might change as we go forward and people need to really make money, which is why before when I said act fast, I think that's some good practical advice. You can use any of this as kind of leverage points and just negotiating something that will ease some of your short-term pain with the other side. So does anybody have any questions, comments, thoughts? We're going to put this up on, I guess, Facebook. So if you have questions down the road, feel free to post there. But we'll hang around for a few minutes in case anybody has questions. I don't know, Cooper, if you have any other thoughts that you wanted to throw in before we closed up.
Sorry, I keep muting myself. No, let's see if anyone has questions. I guess they can either write them on the side. David, how does this work? They can either write them on the side, or they can
go ahead and unmute and just ask a question at this point.
Okay. Let's give everyone like a minute to just see if anyone has anything. Just hang out for a second.
Yeah.
Is someone trying to talk? I think some people might be muted.
Why don't you just unmute everybody, David? If anybody wants to talk, feel free to.
Hello?
Hey.
Hi. I'm Harry Miller. I know Mike Flynn. I know you, Lee, a little bit.
Hey, Harry.
Hey, Harry.
So very informative. Thank you, guys. I'm coming at it from a little bit of I'm a broker, a commercial real estate broker. I've negotiated a lease with in an owner-occupied building in Long Island, and the owner is on the first floor. The new tenant is on the second floor. They're in the process of moving in. My commission has half of my commission that I was due was paid already upon their occupancy. And then the next commission payment that I'm set to do is April 1st. So I guess just from the brokerage point of view, regardless of what happens with the tenant, whether the tenant just tries to, get themselves out of the lease in some way, I guess I'm just wondering if in worst case scenario that they do, I'm not anticipating that, but if they did, how would I, what would my standing be as being able to collect the balance of that commission?
Yeah, that's a good question. And you have, I'm assuming the commission agreement you have is pretty standard looking. It looks like most of the ones that we've
Yeah.
seen.
I think so, yeah.
And that's going to provide that, assuming that the tenant hasn't defaulted by that date, by the April 1st date, that you'll be owed the other half of the full commission.
I think, if I'm not mistaken, I think that the commission says that it was earned completely upon the signatures and occupancy of the space, and the tenant has occupied the space, partly, not maybe completely fully. So,
Right.
So that's it. And the fact is, the tenant actually is a very high quality tenant as well. So, whatever that means, but
Yeah,
so
I would think contractually, if there's nothing written in there that states that there can't be an ongoing uncured default at the time that the second installment is payable, then yeah, you contractually, I think that you should have the right to collect that. And if the landlord decides not to pay it, and they say, well, they didn't even really get a couple of months underway and they're defaulting and I don't care what the cause is.
mhm.
I think you have a pretty good case. You would hate to have to litigate that. But I think I don't think you have to go too much beyond the four corners of the contract, because it sounds like you have a pretty clean right to receive that. Just the installment is delayed,
Right.
which is pretty typical.
Mhm.
So yeah, Harry, if that comes to pass, obviously you know how to reach me.
Yep.
I'd be happy to look at it with you.
Okay, thank you.
No problem.
Mike, just a question for you on top of Harry's point. Does this go back to a ready, willing, and able type of buyer, and that's what the broker is responsible to provide? And once that's done, they are entitled their payment?
It's a little different on a lease. So Harry's talking about a commercial lease, which typically the full commission is earned when it's signed and all the deliverables are in place. Sometimes you can negotiate for things like them not being in default when the second installment is due. But if there's just if it's timed out, so as long as they've moved in, it's just paid in 2 installments. It's not even that they were ready, willing, and able. They executed that lease. Harry, as the broker, fulfilled his task, which was to not just find a ready, willing, and able tenant, but he got them across the finish line. He got them to deliver first month's rent, security, and a signed lease, and they're locked in. The broker obviously is not in control of the tenant's performance after that point. They're not a surety of that. But I think what you're talking about is going to come up. We'll probably see this come up in the sales context, where there's a listing agreement that provides that the commission is earned, and it may even say, due at closing but earned when there's a ready, willing, and able buyer brought to the table. And you'll see variations on it, but if it's unmodified and it's earned and then that person walks away, that we could see some lawsuits from that. But yeah, it's a little trickier with the sale because the broker in many ways does the majority of their work to get it to the point where it's going to be in contract. And then you have this closing period where there's some intervening things that could stop it from closing. But I think in most of these cases we're talking about, it's going to depend on the wording of the contract. I don't think we'll have to go too far out of the four corners to resolve those.
Thank you.
And good thing to bring up, David. Anybody else on there?
No, I think
We can take questions, by email or privately too. I don't know if everybody,
yeah.
wants to air their thoughts or questions. Maybe we stimulated some ideas and maybe some people are on here just to think through some of these things and how it might impact them. So
And
hopefully
like I
everybody
said,
can
I
find
think
us.
this is going to be a continuing issue, and our plan is to do one of these a week on different topics. So there'll be an opportunity to ask questions in the future, and I'm guessing we'll probably have to revisit this topic in the next couple of weeks because the things are going to change, and we'll get feedback from our colleagues and clients and friends about how it's impacting the business. Someone's making a phone call. Maybe just mute everybody again, David. We don't hear somebody's phone conversation.
No, I muted that one.
Okay.
So just, I don't know, something interesting as far as the acts of God clause that's in these force majeures. My understanding is that acts of God is not due to human agency. Interestingly, this morning, I think in NBC was talking about this virus and saying that it's a totally natural virus, that this wasn't caused out of any kind of human lab or wasn't concocted, but is a virus that would almost happen anyway, naturally. And so I'm just wondering if that might strengthen, the acts of God clause.
Yeah, I mean, I think the acts of God piece is going to come down to
Handsome on this.
what the courts decide.
Oh, there.
So,
Meli.
David, can you just mute everybody so I don't.
Yeah, I think Ginger is trying to talk, but I can mute it.
You can speak up. We've done enough talking.
Yeah, no, I was just going to say, I think it's a good point, David, but that issue, whether or not this constitutes an act of God, to me, it seems pretty obvious it is. I know we talked about it internally, and there was some dissension on that point of view, but I think ultimately courts in New York will make that decision.
I think in most cases they're thinking of acts of God the way it's written. It's kind of an antiquated provision if you think about it. To even reference it, and a lot of times you'll see it repeated a few different ways: acts of God or other unforeseeable events. Because that's really the key. Is
right. I'm kind of grouping those two together.
Yeah, I mean, if you think about it, if you're again, I'm going to be kind of like devil's advocate here because what else are lawyers good for? If we're calling this a natural disease that was, created, sure, you can argue God created all of us if that's your belief, but and with that we're viruses, right? You could also say, well, if it's a natural disease, then we can't evoke force majeure for the flu epidemic if we have a bad flu year, hay fever. I mean, anything that comes up. You could flip it and use the argument against that person. So I think in most cases, when we're talking about acts of God, we're talking about things like an earthquake. Is that foreseeable? In some places, yes, but I wouldn't expect you to have a great case in Los Angeles or along the San Andreas Fault that we couldn't foresee that there might be a minor earthquake now and again. I think this context is very important for this provision. And
Mike, Daniel has a question. He's in the middle of construction in a rent-free period. I just wanted to open it up for Daniel to be able to ask a question.
Sure.
Hey guys, thank you for your time. I have a force majeure clause, but I'm in the middle of construction, and then I have a 5-month free rent period. So how does that work? Am I able to invoke the force majeure clause, or is that something I should just address with the landlord first?
This what kind of space is it, Daniel? Is it retail space?
Yeah, it's a real estate space.
Okay. Yeah, I mean that's and you have 5 months of free rent at this point ahead of you?
Yeah, so I have the 5-month free rent period that started in January.
Okay.
So I'm kind of like in the middle of that free rent period, and Unfortunately, the county is gonna shut down any construction starting Saturday. So that kind of limits what I can accomplish during that free rent period. So
I think that again, we can look at this offline, but I think normally when you have things like a construction timeline to build out space, there are little elements of this, like things out of your control, tolling the time period that you have, or if the landlord is building it out. Usually something like this might fall under one of those tolling provisions, so that if it's not due to your fault or negligence that you're delayed, I would expect that if you have a work letter or some other provision that addresses the build out period, that there should be something in there that extends the period for events like this that are out of your control. And that could actually be a good thing, because if you literally cannot complete the build out and commence operations, you may be able to get in and be able to start operating the business when this is blown over. But yeah, that's an interesting one, because you're right in the middle. We could take a look at that for you. Did you have counsel help you negotiate that when you entered into the lease?
yeah, I had counsel look over that. So
Okay. I mean, that, we don't want to step on people's toes if
Sure.
you wanted to bring that up, but off the bat, I would look specifically in the work letter or the initial alterations provision, and see if there's there should be, I would think, some language that tolls the period for things that are outside of your control. Union strikes are like a more common thing that might be thrown into a provision like that. Or, again, we'll use the other acts of God. That's likely language to be in there, but that'll be separate from force majeure, I would think.
okay, thanks, guys.
Sure.
And look, I mean, I think this is big picture, not talking specifically about Daniel's situation, but, courts are going to look at this from a fairness perspective and try to figure out what to do with respect to the impact this has had. And in somebody like Daniel's situation or a similar situation, you have to kind of look at the intent of the parties. The intent of the free rent was clearly to give Daniel the ability to perform his work. That purpose is now going to be impossible, right? By virtue of the government saying you can no longer do work. So it sounds to me like even if there's not language in the work letter itself or the lease, which there might not be, there should be, but there might not be, still might be some good arguments for Daniel or somebody similarly situated to use in negotiating the point with the other side. And you're going to want to get out in front of it. You're not going to want to just wait 5 months and say, okay, well, this should now be extended another 5 months or whenever you can get back in. You're going to want to make sure that you and the landlord are on the same page right away about what's going to happen once you're allowed to start working again. I think we are, I know Ginger had jumped in. Did you have a question or was that just a mistake on mute?
I was talking about you.
Oh, okay. All
You
right.
know who Ginger is, don't you?
Well, I see in the comments who it is. Hi, Linda.
Okay.
How are you?
Good.
All right. Anybody else have any questions? Otherwise, we'll wrap up. And again, we'll put this on Facebook for people to listen to. And then we'll try to do one of these once a week.
Thank you very much, guys.
Thank you.
Thanks, everybody.
Thanks for joining.
Stay safe.
Everybody be well.
Yep.
Yeah. Same
Yeah.
to you guys.
Okay.
Bye-bye.
Bye.